The European Union isn't a state. International responsibility for illegal, unreported, and unregulated fishing activities. This paper focuses on the responsibility of the European Union in the context of illegal, unreported, and unregulated fishing activities. It aims to debate some of the legal issues that characterize its role as a global actor dealing with marine resources and the protection of the environment. For this purpose, I analyzed an advisory opinion of the International Tribunal for the Law of the Sea in order to describe the interplay between obligation of due diligence and attribution of conduct. Finally, I focus on international customary law possibly binding EU member states. The paper points out the unnecessary level of complexity employed by ITLOS to establish the responsibility of the EU, excluding that of its member states, and construct a simplified form of EU responsibility applying the articles developed by the International Law Commission on the Responsibility of International Organizations. This paper focused on the responsibility of the European Union or EU in the context of illegal, unreported, and unregulated or IUU fishing activities. It aims to debate some of the legal issues that characterize its role as a global actor dealing with marine resources and the protection of the environment. Due to the significant absence of judicial practice concerning the international responsibility of the EU, this advisory opinion serves as a fundamental decision in the discussion on the complexities of its status in international law and, in particular, under the law of the sea. The reason I wish to discuss this opinion after a conspicuous number of academic commentaries is that I would like to present a way to reduce the complexities of the argumentative structure employed by ITLOS. I believe that the intention to preserve the status of the EU as a sui generis international organization played an unnecessary role which complicates the argumentation and negatively affect the protection of biodiversity. Conversely, I will apply to the present case the articles developed by the International Law Commission or ILC on the responsibility of international organization or ARIO, which are not mentioned by ITLOS even though they were extensively debated during the proceeding. I have three main claims that clearly diverge from the position of ITLOS. The standard of due diligence applicable to the EU is different from the standard of due diligence that is applicable to member states. The relevant conduct is attributable to the EU on the basis of Article 6 ARIO and not on the basis of the so-called normative control. EU member states cannot hide behind the institutional veil, but bear obligation based on customary international law to provide all means to enable the organization to fulfill its obligation. The advisory opinion. The Subregional Fisheries Commission, or SRFC, is an international organization established in 1985 which has 7 member states. Its purpose is to strengthen cooperation between these countries in the field of fisheries management. In 1993, the SRFC member states signed a convention on the definition of the condition of access and exploitation of fisheries resources on the coastal zone of SRFC member states. This was reviewed in 2012 by the Convention relating to the definition of the minimum condition of access and exploitation of fisheries resources within the maritime zone under the jurisdiction of SRFC member state. The 2012 convention conferred to its members the right to authorize access to fishing vessels belonging to non-members to the allowable surplus of resources in the maritime areas under their jurisdiction, establishing a system of fishing licenses and the condition for the management of the resources. As of 2013, there are 18 agreements in force between SRFC member state and between a third party and an SRFC state. The EU, the only international organization involved, currently has two agreements with Cape Verde and Mauritania. The SRFC reported several cases of IUU fishing activities in the areas it regulates. IUU activities are a threat to the conservation of ecosystem, causing the drastic decline in major stock of fish resources in the sub-region. Moreover, they cause nautical losses for West African countries and endanger local communities of artisanal fishermen. 2012 Convention defined IUU activities distinguishing between three practices: illegal fishing, fishing activities conducted by national or foreign vessel in waters under the jurisdiction of a state, without the permission of that state or in contravention of its laws and regulation, conducted by vessel and fishing the flag of state that are parties to a relevant regional fisheries management organization but operate in contravention of the conservation and management measures adopted by that organization and by which the state are bound or relevant provision of the applicable international law, or in violation of national laws or international obligation, including those undertaken by cooperating state to a relevant regional fisheries management organization. Unreported fishing. Fishing activities which haven't been reported or have been misreported to the relevant national authority in contravention of national laws and regulation, or undertaken in the area of competence of a relevant regional fisheries management organization which haven't been reported or have been misreported in contravention of the reporting procedures of their organization. Unregulated fishing. Fishing activities in the area of application of a relevant regional fisheries management organization that are conducted by vessel without nationality or by those fishing and flying a flag of a state not party to that organization, or by a fishing entity in a manner that is not consistent with or contravenes the conservation and management measures of that organization, or in areas or for fish stock in relation to which there are no applicable conservation or management measures, and where such fishing activities are conducted in a manner inconsistent with state responsibilities for the conservation of living marine resources under international law. Concerning the fact of the case, for the purpose of this paper, it is relevant to point out that in 2010, one of the SRFC member states boarded two vessels which were fishing under a memorandum of understanding signed with an international organization. The vessels were in breach of the legislation of the coastal state, leading to an outstanding. The owner recognized the violation and paid part of the one on the spot. Consequently, the vessels were released with the assurance of paying the entire one within an agreed period. However, it transpired that the remaining one was paid, and the SRFC member state asked the international organization to take the appropriate measures to pay the one. In response, the international organization declared itself incompetent both to oblige the flag state to pay the WAM and to pay in lieu of the flag state. Thank you.